Professor Blackman.
Thank you. Chairman Durbin, Ranking Member Grassley, thank you for inviting me to testify. My name is Josh Blackman, and I'm a constitutional law professor at the South Texas College of Law, Houston. I support the confirmation of Judge Garland. He should be swiftly confirmed. In my brief time today, I will discuss 3 current DOJ policies that I hope Attorney General Garland will maintain. First, DOJ lawyers should not give legal effect to so-called rulemaking by guidance. Second, Attorney General Garland should carefully scrutinize consent decrees, especially those reached through so-called sue and settle. Third, DOJ should not resume the settlement practice of giving third-party payments to non-parties. That money should be returned to the Treasury. These 3 issues may seem fairly low profile, but each practice will have a huge impact on the separation of powers, and these issues should be important to people on both sides of the aisle. I hope that Attorney General Garland will retain current DOJ policy with respect to these 3 issues. First, the Department of Justice should not enforce rulemaking by guidance. In the past, federal agencies avoided the formal rulemaking process and instead issued various guidance documents. For example, substantive changes to the law were made through Dear Colleague letters, frequently asked questions, and even online bulletins, what I called government by blog post. These guidance documents are not supposed to have the force of law. However, courts grant our deference to the sub-regulatory dark matter. In 2018, Associate Attorney General Rachel Brand instructed DOJ lawyers to not treat violations of guidance documents as violations of the law. And President Trump signed Executive Orders 13891 and 13892, which ordered other agencies to adopt the principles from the Brand memo. Unfortunately, President Biden rescinded those executive orders on his first day in office. At present, the Brand memo is still codified in DOJ regulations. I hope that Attorney General Garland will maintain the Brand memo. Second, Attorney General Garland should carefully scrutinize consent decrees. These agreements include intricate requirements that DOJ could never impose through regulation or litigation. And these consent decrees can exist in perpetuity. During this time, federal judges and court monitors can oversee state and local governments. Such agreements raise distinct federalism concerns. Indeed, many of these agreements arise from a practice known as sue and settle. Organizations and local governments would sue a like-minded agency, knowing there was no adversity, and reach favorable settlements. Fortunately, Attorney General Sessions took actions to restrict those consent decrees. The Justice Department imposed restrictions on consent decrees, including limits on duration, sunset provisions, and means for termination. Critically, under Attorney General Sessions' guidelines, a consent decree could not be used to achieve a policy goal that could not be obtained through litigation. I hope Attorney General Garland will maintain this policy. Third, the Department of Justice should return any excess settlement funds to the United States Treasury, rather than make third-party payments to progressive groups. These payments have been criticized as settlement slush funds. The federal government has allowed billions, not millions, billions of dollars to be given to third-party nonprofit organizations. These special interest groups were not parties in the litigation and were not victims of misconduct. Indeed, Senator Grassley has observed that the Justice Department directed funds at organizations that Congress had defunded. In this way, the executive branch bypassed the Constitution's appropriations process. In 2017, Attorney General Sessions prohibited the inclusion of third-party payments in settlements. Any excess funds from settlements would be restored to the United States Treasury. Attorney General Garland should maintain this policy. Thank you for your time, and I'll be happy to answer any questions.
Thanks, Professor.
I have an important question for Professor Blackman. Historically, the Solicitor the Solicitor General's office has been seen as representing the permanent interest of the government, not political interest of any single presidential administration. Paul Clement, in that position, quote, said, "It has been the long-term position of the Justice Department to defend the constitutionality of statutes whenever reasonable arguments can be made," end of quote. So far, we have seen the Biden administration change its litigation position on a number of high-profile cases, and I would expect that might continue. So, two questions to you. I'm going to ask them both at the same time, Professor. If a case is being litigated, what's the standard for whether to change a position? And is a simple political disagreement enough? And how does the Supreme Court view an administration changing its litigation position?
Well, thank you, Senator Grassley. It's a pleasure to be here. In the past, the Supreme Court has been very critical of changes of position. During the Obama administration, Chief Justice Roberts in particular went after some of the lawyers from the government saying, "Why did you change your position?" And the answer is always the same. Upon further reflection, we have a new position. And upon further reflection is really code for upon further election, rather than a simple change in position. I would hope if General Garland is in the office, he decides to switch a position for the court, he gives some reason why. It can't just be we have a new president. If that's reason, then state it. But maybe there's some judgment about the law. But I suspect at some point the court will get annoyed that all these positions keep flipping on a fairly regular basis.
Professor Blackman, recently President Biden announced that he wanted the Department of Justice to review its policy on allowing it to divert some of the money from settlement agreements to third parties who are not even parties to the lawsuit. The goals of the settlement agreement between the department and a private party, say a bank or a business, are to compensate victims, as you know, redress harm and deter unlawful conduct. So it strikes me as a little odd and highly problematic that we would let the Department of Justice pick and choose their favorite charities or political causes, even perhaps, at the expense of making the victim whole, which of course is the whole goal of compensating the victim. Would you give us the benefits of your thoughts on changing this policy, so allowing the sharing the proceeds of a settlement or a jury verdict with non-parties to the litigation?
Thank you, Senator. Attorney General Sessions adopted a policy that I thought was quite salutary. It prohibited these so-called third-party settlements where the government would pick and choose which charities would receive millions and hundreds of millions of dollars. Senator Grassley, who stepped out, was a key hawk on this issue. In the Bank of America settlement, I think hundreds of millions of dollars were directed to various charities that had no connection to the actual offense. I think there's even a constitutional problem with these settlements. If there's any excess money, it should go to the U.S. Treasury. Congress then could choose to fund or not fund these settlements. Some of the charities that were selected for these settlement funds were actually defunded by Congress. So these are end runs around the appropriations process. It's disappointing that the Biden administration is revisiting this policy and suspect it'll be abandoned. I can only hope that Judge Garland will perhaps be more judicious in giving these vast amounts of money to groups who are in no way affected by the litigation.
Professor Blackman, let's go to you for a second. Is there a point at which what's known as prosecutorial discretion simply becomes executive fiat? And if so, at what point does that run afoul of the Constitution?
Absolutely. The president has a duty to take care that the laws are faithfully executed. And that means something. Congress gives the executive some latitude, some discretion, but the president can't simply decline to enforce a law he dislikes. And I think we've seen this pattern all too often. I think some of the executive actions in immigration have amounted to an abdication of the law. I think even in the first 100 days, the Biden administration tried to say no more deportations for 100 days. I don't think he has that much discretion. We've seen perhaps a complete moratorium on the death penalty. That can go beyond the bounds of discretion. I think Congress should perhaps do more to legislate to make clear what those rules are. But I'm troubled by the failure to faithfully execute the law. It's something that I think we're seeing increasingly.
So you mentioned prosecutorial discretion being invoked as a doctrine in the context of immigration. I assume you may be referring there, among other things, to DACA. It reminds me of a piece that you wrote with my friend Ilya Shapiro about 1.5 years ago, in which you said that if federal law, in fact, supported DACA, then certain key important provisions of the INA would themselves run afoul of the non-delegation doctrine. Can you explain what you mean there?
Of course, and I'm thankful my colleague at Cato, Ilya Shapiro, gets a shout out. Congress has created a very elaborate scheme of granting discretion to the Department of Homeland Security. For example, you can let the Secretary set priorities. That's a fairly nebulous provision. You can set priorities. The Obama administration, and perhaps now the Biden administration, has said these nebulous provisions about granting discretion to set priorities let them basically create this elaborate program by granting lawful presence to over 1 million people and grant them work authorization. If you can read the INA that broadly, then the entire INA is perhaps unconstitutional, right? You should not be able to read it. The Supreme Court punted on this issue. Chief Justice Roberts does what he often does and declines to decide important questions. They just didn't decide it. But eventually the courts will have to decide the DACA litigation. And this is something that Attorney General Garland will be litigating now, defending the policy for the new administration.
So in other words, you've got concerns with the notion that the President of the United States could just tell the Department of Justice in advance to not comply with this specific provision of the INA. That would concern you.
Oh, very much so, yes.
Section 241 of the INA, of course, provides that, quote, when an alien is ordered removed, the Attorney General shall remove the alien from the United States within a period of 90 days, close quote. On what planet, in what universe would it then be appropriate to convert the word shall into may not, or may decide not to?
That's exactly right, Senator. Generally, the word shall means must. That's how we read the word shall in the law. And Congress has created a very elaborate scheme by which the Attorney General can cancel removal. There are very specific rules. But the moratorium enacted on day number 1 was across the board. It's every deportation shall stop. A federal judge down in Texas, in Corpus Christi, declared that policy unlawful. As far as I'm aware, that's not been appealed up. That's still in the district court. I think we'll see more of these sorts of efforts to try to just not enforce parts of the law that are unpopular. Yesterday, Senator Sass made a point that over time, Article 2, the executive has grown. Well, Article 1, the Congress sort of shrunk. I would hope it reverses and Congress asserts itself more over immigration and put some teeth into the limits on the president's powers.